Welcome to today's webinar, Accommodating Mental Health in the Workplace During the Pandemic. My name is Katherine Pollock, and I'm a partner in Fasken's Labor, Employment, and Human Rights Group, and also happen to be chair of the partnership board. I'm going to be joined today by my labor colleagues, Alix and Rachel Younan. While the three of us are from the Toronto office of Fasken, what we're covering today, mental health in the workplace during the pandemic, is generally applicable, we believe, to all of Canada. And whether you're federally or provincially regulated, I think what we discuss today will be of assistance to you. We have over 1,100 registrants from across Canada, and we're very pleased to be giving this important presentation. But before we jump in, a few housekeeping notes. First of all, at the end of the webinar, please click the survey button underneath the video. These surveys help us to determine future topics, and your input is greatly appreciated. As well, the materials for today's webinar can be accessed via the Materials tab at the bottom of the screen. We are also recording today's webinar, and the recording and materials will be emailed out post-event. During the webinar, if you have a question, please click on the Submit Question button to send us your questions. We will do our best to answer all the questions we can, and in fact, we've reserved 10 minutes or 15 minutes at the end. We also got some great questions as people were signing up for this event, and so we hope to cover those questions during our presentation. If you require technical support, please click the Tech FAQs or Tech Support chat buttons, and one of our techs will help you out. If you're looking for COVID-19 specific information, we have a wealth of information in our COVID-19 Knowledge Center, which can be found at fasken.com. Finally, and last but not least, our next webinar will be held on May 4th, beginning at 2 p.m. Eastern, and the topic will be Effective Progressive Discipline and Performance Management Strategies for Addressing Poor Work Performance, Behavior, and Misconduct. Please visit the Fasken Institute section on fasken.com or to register for this event and for information on all of our fabulous upcoming events. So, without further ado, let's look at the agenda for today. Over the next 90 minutes, we're going to be covering some really important and key issues for all HR experts and specialists. The rise of mental health issues during the pandemic and their impact on the workplace, building awareness amongst all of us on how these mental health issues are affecting our employees and how we manage those mental health disabilities. We'll be looking at the legal framework, principles and issues when looking at and requesting medical information, what some of the consequences are of poor disability management if we need reminding. We've set aside about 15 or 20 minutes to do a case study where the facts that we're going to go through will allow us to apply, we hope, what we've learned. And finally, we hope to leave everybody with practical strategies for supporting employees' mental health during the pandemic. So, to begin at the beginning, first of all, that picture of me is with my pre-pandemic haircut. Please change that slide. Okay. I think it's fair to say that as HR specialists and lawyers, that we have been, in a way, the gatekeeper to manage mental health issues in the workplace, both pre and now during the pandemic. And by what I mean by gatekeeper is that we are the ones who are being asked to assist employees who are dealing with mental health issues at the same time as we're dealing with the business, saying we need people to be effective, we need people to be able to work. Mental health is a huge issue in Canada. It was before the pandemic, and it is most especially now in the last year and a half. And what's up on the screen right now are just some snapshots of some headlines where, for example, 76% of Canadians have said that the pandemic has affected their mental health. More and more Canadians are reporting anxiety and depression than ever before. Canadians' mental health is eroding as the pandemic continues, according to a national survey. And organizations are hitting the alarm button saying that we're about to experience a second pandemic of mental health. Let's take a look at some additional statistics on the next slide. So we know that COVID-19 has dramatically impacted the mental health of Canadians, so all of our employees. If you look at how people rated their mental health in 2018, about 8% rated their mental health as fair or poor, which is not great, but that was 8%. Now, during the pandemic, about a quarter of Canadians rate their mental health as fair or poor. And indeed, half of Canadians are reporting that their mental health has worsened since the pandemic began. Physical distancing measures have been put in place. Mental health has worsened. The vast majority, 88% of Canadians have indicated that they've experienced at least one symptom of anxiety since COVID-19. And we know that people who have said that they've experienced anxiety don't mean just a momentary flash of anxiety, but from moderate to severe anxiety. We also know higher anxiety is reported among those who have been financially affected by COVID-19. Next slide, please. We know that in the last year, that COVID-19 has impacted everyone differently. And as HR professionals, this is something that's absolutely key as we look at those employees of ours who are experiencing mental health connected to or at the same time as COVID-19. COVID-19 impacts everyone differently. A recent CAMH study found that those who have lost their job due to COVID-19, or those who are worried about their personal finances, those with kids, especially young kids of school age, and young people, are more likely to experience anxiety and or depression. This is a huge issue. We also are aware that groups that are vulnerable to infection and severe impacts from COVID frequently intersect with racialized and Indigenous communities and people with disabilities. Those people are experiencing COVID-19 in a more significant way than others. At the same time, we know that there is a rise in substance use and abuse issues. Prior to COVID, about 14% of Canadians reported consuming cannabis, and heavy drinking behaviors were pretty stable pre-COVID. Since COVID-19, some Canadians have reported increases in their alcohol, cannabis, and tobacco consumption. We know that increases in cannabis use are highest amongst those aged 15 to 35. And we know that there's been an increase in alcohol use, highest among those aged 35 to 54. The CBC just had a piece on the other day about how women in particular have been increasing their alcohol use. And after over a year of COVID, many of us are saying better not be ingesting quite this much alcohol, especially when COVID doesn't look like it's coming to an end. So people are turning the corner, understanding that there's a substance use issue, and are looking for some assistance. The reason we're looking at substance use is, of course, the definition of disability under both federal and provincial human rights codes deals with alcohol and drug consumption. Al?
Thanks, Katherine. I thought it would be helpful for our attendees to have a sense of how the new realities of remote work for many of our clients has changed since the pandemic started. So we're obviously now a year into the pandemic, and 1 year ago, I think we would all agree that only a fraction of the Canadian workforce worked from home. And this was really at the employer's discretion, right? We often would have requests, and it would be really, unless it was an accommodation, it would really be based on the employer's business needs. In the pre-pandemic period, interestingly enough, 10 to 13% of employees worked from home. And by the end of March 2020, so the first month of the pandemic, we saw almost 40% of work is now being done remotely. So obviously the shift occurred because not only did we have governments mandating, as we're currently in Ontario, a stay-at-home order, but also many provinces have encouraged remote work unless attendance at the workplace is required by the nature of the work. So while we've had the shift to working at home, this has created some advantages for some employees. You know, we've heard anecdotally, some employees like not having to commute to and from work. Some commuting could be upwards of 2 or 3 hours a day, and they really appreciate having that extra time. But what we've also seen is that working remotely has brought up feelings of isolation, of blurred boundaries between professional and personal lives, and competing responsibilities with child and elder care that can cause employees to feel overwhelmed during an already stressful period. We've also seen for employees whose duties don't allow them to work remotely that they have fears related to the pandemic, which have been compounded by having to either travel to work using public transportation or being in the workplace with other employees. So obviously for some employers, they've been able to adapt their operations to create a work from home environment for a longer term. And some of our clients are actually saying to us that this may continue for some time into the future. Whereas other employers have, will be obligated to return operations to the pre-pandemic state. In either case, whether you're asking employees to come back to the workplace or you're going to create a new work from home balance with the office, the mental health needs of employees and the operational needs of employees will require some balancing. And this raises some important challenges that employers are facing. We've heard a lot from our clients that lots of employees have indicated some fear or anxiety about returning to the workplace, including anxiety around vaccinations and whether all employees will be vaccinated when normal operations resume. This is obviously compounded by the delay in the vaccination rollout. We've obviously had employees raise issues with fatigue and burnout from the ongoing demands of balancing your professional and personal responsibilities. I'll talk more about that in a minute. And then obviously, we've had issues around promoting social connections and team morale while people are working remotely, or if required to attend at the workplace, maintaining physical distancing measures. Obviously, monitoring employee mental health through limited virtual communications or not being able to have one-on-one meetings in close proximity with employees can also be difficult for employers. So if we move, thank you, Andrea. So if we focus on employees who are working remotely, we should all be aware of the new realities at this point, right? We're all now used to Zoom and Skype and WebEx and Teams. And whereas, lawyers in particular were never very good at video conferencing, we've all become quite expert in the last year. But obviously it also has its own, unintended results. And so I thought I'd work you through some recent studies that will highlight some of the issues that employees are facing. So in September 2020, a study from the Harvard Business School analyzed the emails and meetings of 3.1 million people in 16 global cities. And they found that the average workday increased by 8.2% or 48 minutes during the pandemic's early weeks. Employees also participated in more meetings, even though those meetings were slightly less in time. The study also found out that employees sent 5.2% more emails a day. About 8.3% more emails were sent after business hours, so there was an increase in after-hour work. And obviously, there was 13% more meetings, and at those meetings, more people were required to attend, and that obviously saw an increase of at least 14%. So there's a general sense that I think most employees feel that we never stop being in front of Zoom, and you have to sort of show a concentrated face the whole time, which can be quite draining. So, we also saw that in a recent March 2021 Microsoft study, they found that the average team user sends 45% more chat messages per week and 42% more after hours messages. So the data from Microsoft also shows that workers feel compelled to respond to team chat messaging quickly. And 50% of those that responded indicated they responded within 5 minutes or less. So, we're obviously seeing increased pressures on employees to be super responsive, because there is definitely a feeling that, well, we're all at home, we're all stuck at home, there's no real excuse for not responding right away. I thought this was an interesting statistic, and so I thought I'd share it with the group. In this Microsoft study, they found that between February 2020 and February 2021, the number of emails that were delivered globally increased by 40.6 billion. So we're obviously seeing an increase in traffic on the amount of emails. And they also found that weekly meeting times more than doubled. So clearly there is, obviously resulting mental health issues that arise from the increase in the different types of working that employees are doing, the increased use of computers and emails, etc. So, when we think about having an office in your home, combined with the fact that most people now are glued to their phones 24/7, there's not much else that we're doing in any given day. And so the separation of work and life has become very difficult and nearly impossible for some employees. And this has caused burnout. And we have seen in the last number of months a lot of articles talking about burnout that employees are facing. The World Health Organization has defined burnout as feelings of intense fatigue, loss of control, and accomplishing nothing at work. I mean, who out of all of us hasn't felt like we've worked all day and accomplished nothing? So we're all having days like that. So I thought it'd be interesting to share what Microsoft's annual World Trend Index is showing. So they're showing that there is high productivity of employees, but that is masking the exhausted workforces globally. And interestingly enough, the situation is worse in Canada. A survey was conducted of 30,000 global workers, and it suggests that 47% of workers report feeling exhausted during a typical workday, compared with a global average of 39%. So why are Canadians in particular feeling more exhausted during the day? Well, they didn't look at that in the study, but some of the articles that I've read and some reports by Microsoft have indicated that while workers are working at home more, they're not decompressing before the start and the end of their day. They're not taking time to set themselves up for a positive day and decompressing at the end of the day. And really that comes from the loss of commuting time, that time that people would use to kind of set themselves up to start the day. And at the end of the day, to kind of decompress on your way home, all that commuting time is now just being filled with more work. And so that leads to the second statistic on the slide, which is that Canada's stress levels are higher than the global average, with more than 50% of Canadian workers report feeling stressed. And one of the top causes of the rising stress levels that were reported by Canadian workers is this lack of separation between their work and personal life. So obviously, that's the main issue. And so one of the final points I wanted to make for the group today is that this report also showed that 40% of the global workforce is likely to consider leaving their current employer within the next year, with nearly half planning to make a major pivot or career transition. So employees are feeling frustrated and stressed and are likely to want to move in the next year. So the study confirms that they're looking for employers that put their well-being first. They want the ability to choose where they work from, whether it's remote part of the time, remote all of the time, and they want flexibility over their schedules as they balance their personal lives and responsibilities of family as well. So if employers respond appropriately, they will likely have more engaged employees that will be retained. And finally, when we talk about mental health, it's important to look at it, not to look at it in isolation, right? What we've seen in the number of the issues that we deal with for our clients is that there is an intersectionality between issues of mental health and other issues. And we've heard this term intersectionality used before, but it's become more prevalent during the pandemic. And it really, looks at a variety of how we identify to ourselves. Is it based on our race, our class, our gender, our sexuality, religious beliefs, social class? And no one identity is necessarily more important than the other, but everyone values different things differently. So while the way we identify ourselves as personal and varied, the way society may treat people based on these identities can often cause some issues in the workplace, including patterns of discrimination and disadvantage. So really, intersectionality refers to the overlap of these social group categories and identities. So when we consider how mental health may be impacting our employees, it's important to consider some of the other issues, like family responsibilities of caring for children or for elder care. We have to look at, what men may be facing in terms of their ability to express their emotions and whether they will seek help for mental health issues versus other people. So when we're dealing with an employee situation, it's important to understand the full context of what that employee's reality is and the intersectionality of mental health with race, gender, and other family responsibilities.
So now that we've talked about the context of the pandemic and of the mental health issues that are arising coming out of the pandemic, let's dive into the legal framework, and this will really ground our conversation going forward. So as we have up on the slide here, of course, it always helps us to remember and to remind ourselves what the definition of disability is. So we've got up on the slide here the definition in the Ontario Human Rights Code and in the federal human rights legislation. But certainly the definition of disability is a complex and evolving matter. So we all need to always take a look back and think about that definition. Generally speaking, disabilities have the following characteristics: permanence, so the condition must not be transitory. Impairment, so something that impairs an employee's ability to work or carry out the normal functions of life. And importantly, disabilities are supported by medical evidence. Important to remember also that the protections in human rights legislation are protections for actual and also perceived disabilities. So we need to be always mindful whether we're attributing a disability to someone who maybe doesn't have a disability as well. So thinking about the perceptions that we have too about those with about disabilities. As we move to the next slide, when we think about mental disability is really defined as a significant clinical pattern of behavior or emotion associated with some level of distress, suffering, pain, death, or impairment in one or more areas of functioning. So that could be, in our case, we're focused on work, but that could be at school, that could be socially, and that could be in family interactions as well. And, important to distinguish between a mental disability and a mental health concern, which is, a little bit more about a concern that's held by an individual due to a perceived deficit in mood or a thought that's distressing, but perhaps hasn't been present for an extended period of time, or perhaps doesn't rise to the level of a mental health disability. Of course, we as a society have now, and particularly in the HR space, we have been speaking about mental health and mental illness more openly over the past number of years. Whether those are national campaigns that are really raising awareness, or it's just, it certainly has become much more discussed and accepted as being an issue that people face in our society. But for many years now, the term disability has legally been found to include mental illness and mental health disabilities at law. And with that, of course, now that it is and has long been accepted as being a disability, mental health attracts human rights protections. And so we need to start thinking about, and we need to remind ourselves always of our obligations under human rights legislation. Now, as the next slide says, not all mental distress or mental health concerns are a disability. On the slide here, we have some examples of statements or references to mental distress and mental health, which have been found in certain contexts not to prove a disability. I think we can probably all remember a time, perhaps more often now, where we or someone we know have made statements like these in passing in conversation. That does not, of course, mean that we're all experiencing a mental health illness or a disability. And you may have heard employees in your workplaces or coworkers say things like this. And we'll talk a little bit more as we go on about what you might need to think about when you hear statements or references of this nature. But again, just reminding ourselves that not every reference to mental health means that an individual has a mental health disability. Let's take a couple of examples. Let's consider workplace stress. Now, in our culture of being busy, and depending on what the nature of your workplace is, often there are high pressure work environments. We often hear statements like, "This is so stressful," or "I'm so stressed," or "I'm underwater," or "I'm drowning in work." Things like that. Those sort of day-to-day conversation points that we seem to all be having and that we're hearing from that our clients are having. But again, workplace stress or stress just generally without more really isn't protected. But also we can't discount a statement or reference to stress. It's not without more. A reference to workplace stress is not a prohibited ground or is not going to garner the protection of human rights legislation. But being mindful of how it may arise from, stress may arise from or be connected to disability or perceived disability is certainly something important to bear in mind. And of course, the fact that it can be, a cause or a symptom of a mental health issue and something that might require accommodation is certainly important to remember. Another example, and Katherine spoke at the outset about how drug and alcohol use is increasing, and we want to also be aware that addiction, as Katherine mentioned, is a protected ground, or it is seen as or well recognized as a disability within the meaning of human rights legislation. That's been for many, many years now, that drug and alcohol abuse have been accepted as a disability and entitled to protection under human rights legislation. I'll turn it over to Katherine now to talk a bit more about the duty to accommodate.
Thank you, Rachel. As all of you are no doubt aware, federal and provincial human rights legislation requires employers to accommodate employees who have a disability up to the point of undue hardship. This duty applies not only to full-time employees, but also to part-time, temporary, and probationary workers. The same general principles that apply to that guide the duty to accommodate a physical disability also apply to your obligation to accommodate a mental disability. There is no distinction to be made. Where you become aware of a disability, it is up to you as an employer, first of all, to identify the disability and the need for accommodation, to collect relevant information, to consider accommodation options, and to implement accommodation and follow-up. Importantly, the duty to accommodate has both a procedural component, which is the process to be followed, and a substantive component, which is the actual substance of the accommodation to be provided. The procedural duty involves considerations, assessments, and steps taken to respond to an accommodation need. A failure by the employer to give any thought or consideration to the issue of accommodation, including what, if any, steps should be taken, is a failure to accommodate. The employer has to seriously consider how it can accommodate the employee who has presented himself or herself with a disability. Serious consideration. The process has to be meaningful. You must show that you've taken this procedural component seriously and that you're tracking these issues. The substantive duty is about the appropriateness or the reasonableness of the steps or the accommodation that you have chosen to provide to the employee. As I mentioned a moment ago, the duty to accommodate is a duty up to the point of undue hardship, which is a really difficult concept to define. In determining what's undue, though, the case law has been clear that it is up to employers and employees to work together, and if there's a trade union, the trade union as well. It's a two-way street or it's a three-way street. It's not all on the shoulders of the employer. There must be participation by the employee and or the union. Importantly, the employee who is seeking accommodation does not have the right to insist on a perfect solution, but just a solution that is reasonable in all of the circumstances. In assessing whether accommodation takes you up to that point of undue hardship, the employer has to look at financial cost. Is there a security issue here? Is there a health and safety issue here? That all of that goes into the mix as you consider whether undue hardship has been met. So, the first step in your duty to accommodate is to identify the disability. So, does your employee actually have a disability, and does your employee need accommodation? There are added complexities when you are asked to accommodate somebody with a mental health issue or addiction. This is because there is a complexity that surrounds the disclosure of mental health issues. There is, I think, as most of us understand and would agree, there still is a stigma, unfortunately, surrounding mental illness. And employees are often very reluctant to disclose that they are suffering from a mental illness. They're worried it will be a career-limiting move, and they're reluctant to come forward. That said, an employer may observe inappropriate behavior or unusual behavior, a change in personality, reduced performance. These can be signs that somebody is struggling and that somebody possibly has a disability. In fact, the employee may not realize that he or she has a mental disorder or disability, and it may be up to the employer to make inquiries. We're clear on this. The employer has a duty to make those inquiries, to address the situation directly with the employee, to consider the possibility of a mental health issue. You cannot sweep this under the rug, much as it sometimes is tempting to do, because to speak to somebody about issues, ongoing issues, can be a difficult conversation to have. But I repeat, you do have a duty to address, to identify if there's a disability, to identify if there's a need for accommodation. You want to do so in a respectful way that appreciates the person's privacy as much as possible. But remember, this person is an employee of yours, and he or she is exhibiting symptoms that are concerning. A key indicator as to whether somebody may or may not be mentally ill, or may be mentally ill, is when an employee begins to behave in an uncharacteristic fashion. For instance, an energetic worker may suddenly become lethargic, or a worker who's usually quiet and reserved all of a sudden starts making grandiose claims. A good worker is all of a sudden experiencing decreased productivity, lack of cooperation, or an inability to work with others. These are all signs of behavioral changes that should be of concern and may be a sign of mental illness. The employee may simply be having a bad day, so you don't want to jump on the first indication of an issue. But if there's a pattern of behavior that continues over a period of time, this behavior may be indicative of a disability that requires accommodation. Looking at how to identify a disability and the need for accommodation, we've listed here what we believe are some common warning signs for employers. Everything from, and these are things that are out of the ordinary. This will help you assist in identifying if there's a disability and if you need to accommodate. If somebody's late or frequently absent, if there's a general inability to work with colleagues, if there's issues with productivity, more accidents, or health and safety issues. If somebody is constantly or frequently complaining of fatigue or unexplained pain, that's an indicator of an issue. If somebody who was formerly a good employee is all of a sudden experiencing difficulty in concentrating or decision making, or is having difficulty recalling things, those are warning signs. If deadlines are being missed and there really aren't good excuses for it, or work's being done poorly, and again, no good excuses for that, those are common warning signs. A decreased interest or involvement in one's work, working excessive overtime over a prolonged period of time, sometimes linked with problems in meeting deadlines or poor work being done. Expressions all of a sudden of strange or grandiose ideas is a common warning sign. Unusual displays of anger or blaming of others. These are all common warning signs that somebody may be suffering from a mental health issue and may need accommodation. As I say, it is your duty to make reasonable inquiries of your employee. You can't jump to conclusions. You can't make assumptions about what's going on with the employee. You can't ignore what is going on with the employee. You must be alert to the warning signs, and you need to make the inquiries. Alix?
Thanks, JP. So over to number 2, which is really dealing with once you've collected the relevant information. As a reminder, this is often a tough place for employers because you don't always get that information quick enough. But there is an obligation on both the employee and the employer to cooperate in the accommodation process. So the employee is required to provide the relevant information, to answer questions and provide relevant restrictions and limitations so that the employer is in a position to assess the accommodation. Obviously, we'll have lots of discussions in a bit on requesting diagnosis and how do we look at the limitation and restrictions, but more on this later on. The third part of the accommodation process is to consider the accommodation options. And I probably said this to a number of my clients who are online today, which is there's no standard accommodation for mental disability. We all know, and as Katherine just indicated, there's lots of different symptoms, behavior, and conditions that can arise if an employee has a mental health issue. And so when you're looking at accommodation, it's important not to just try and apply the same form of accommodation that you may have done in the past, but to really look at the individual and set up what is a reasonable accommodation for that employee. As Katherine said earlier, employees will often have a sense of what they would like as accommodation, and that perfect accommodation may not be a reasonable one from the employer perspective. So it's really, the employer and the employee together coming to an accommodation agreement that reflects the needs of the business, but also obviously accommodates that employee's particular restrictions and limitations. So once you've obviously collected all the information and you kind of have a good sense of what those restrictions and limitations are, you want to look at different forms of accommodation. And we've just listed here some of the more, prevalent ones that we see our clients using. Obviously, with mental health issues, oftentimes we see employees saying that they're not able to cope with the normal pressures of the work environment. And so time off to attend cognitive behavioral therapy or other, treatment like addiction, rehab, that sort of treatment obviously requires some time off. Sometimes employees will often take this off initially, and then you're kind of into the next piece of the accommodation when they're sort of able and to return to work and they're clear to return to work. You're going to look at what kind of job duties need to be modified. Are there opportunities to exchange some tasks with other employees or remove parts of a role that will allow the employee to return to work? And we all know, and the studies show, that it's really important to get the employee back to work as soon as they are able, because once they're back to work, these accommodation measures will be implemented and it'll help them return to work. The longer the employee is outside of the workplace, the more difficult it is to bring them back in. So once we've done that, we'll look at retraining opportunities. We've had situations with some of my clients where lots of changes have happened in the business. If an employee has been off for a substantial amount of time, you may want to do some retraining and allow the employee to attend a certain course that would be individualized and to allow them to feel capable of returning to the workplace, allowing extra time to learn new technology or new tasks. Obviously, we look at flexible scheduling. This can be having a delayed start time or ending work earlier, and that might be to accommodate the effects of certain medication, which sometimes means employees are not able to attend work, let's say at 7 a.m. because the medication is impacting their cognitive abilities, or obviously to accommodate appointments so that employees can continue to get the proper treatment to allow them to fully return to the workplace and perform their full duties. Obviously, we look at things like supervision. How does the manager or supervisor provide instructions on the work? Should this be done in writing, which allows the employee to really think through it and not just have to hear it verbally, which may be more difficult for them at a certain period of time. Obviously, work location right now, if they're able to work at home, you hope that they do have a quiet spot where they can work and be able to focus and concentrate. But if you are in the work environment, finding the right location can oftentimes solve some problems with concentration and focus. And then obviously, having quiet rooms are often recommended for some employees to take extra breaks during the day. Now, obviously, depending on the particular situation, you may want to use different types of technology, which could be using headphones so that they can focus and not distracted by outside noise. That would obviously happen in a customer service environment or in a group environment where people are working closely together. And obviously, modifying the workspace can also be important. Access to employee assistance programs and referral to appropriate services is always a must-do, right? Always remind employees of the tools that you as an employer have available to them that will allow them to get the help they need to ensure that they're able to come back to work and perform their full duties as soon as possible. What employers are not required to do is compromise safety. And, I've seen this often in sort of warehouse environments or retail environments where, employees do certain tasks that may require using certain equipment that may impact the safety of themselves and other employees. So, riding forklifts are not recommended if people are not able to focus and concentrate. So again, you shouldn't be compromising safety. You don't have to keep an employee in a job he or she cannot perform, and that's clear. And that's when modified duties and alternative jobs may be offered. And this is often as a temporary measure, right? So I often recommend to my clients, all these accommodations, shouldn't necessarily be like absolute. They should all be sort of temporary. You should make sure the documents reflect that they're temporary, because the purpose is to really help the employee integrate back into the workplace, manage their job duties with the impact of what their mental health condition may be affecting them with, and then obviously trying to get them back into their normal role. And that sometimes over a long period of time may result in a permanent accommodation, but certainly at the beginning you can work with them through some of these temporary measures. Obviously, you don't have to pay for time off, unless, of course, you provide that as part of your collective agreement or as an employer policy to provide paid sick leave. You don't have to pay for treatment plan, and you certainly can't enforce a treatment plan, but certainly you should facilitate it and provide the opportunity. And employees will often utilize the services provided by employers to access treatment programs that may assist them in dealing with their mental health issues. And this would require the employer to allow time off, but not necessarily to pay for those treatment programs. Now, I do have some clients who are willing to do that for some long service employees and for in other situations, depending on the nature of the workplace, but there's no legal requirement to do so. And then, of course, what's really important, and this often becomes an issue, is that, we set this all up, we go through this great accommodation process, we find an accommodation, everyone's happy with it, people are eager to start it, and then everyone kind of like puts it into place and then forgets about it. It's really important to ensure that you're doing follow-ups once the accommodation is implemented. If you look at the case law, we see so many problems where the communication seems to stop once the plan is implemented, and that can often lead to a failure to accommodate because the employer hasn't taken that extra step to ensure that the accommodation is working. So sometimes these don't have instant success, and I'm sure many of you out there have had lots of problems with some accommodation plans. Sometimes it's a combination of the employees' attitude to the accommodation once they do come back. Sometimes it's the way the manager or supervisor implemented the accommodation, and that can often escalate the issue or create more problems, which then can result in the employee going off again and ultimately dealing with a human rights complaint. So certainly it's important to have regular communication and follow up with the employee. And we recommend that you do this on a regular basis, maybe every 2 weeks or 3 weeks. You're following up with the employee and the manager to ensure that the accommodation is working. Gives you an opportunity to fine tune it. If the employee is doing better than expected, to bring some duties back. If there's more issues and more restrictions that come up, to look at updated medical, make sure that's being included in the accommodation plan, and that you're constantly adjusting that accommodation to make sure it reflects the employee's restrictions and limitations, and ensuring that productive work is being done. And often what we see where problems arise is when discussions are had between human resources and the managers, but ultimately the employee is not kept in the loop and gets frustrated with the accommodation changing or ending, or not feeling that they're up to date on what's happening. So very important to keep that clear and updated. And we recommend, of course, that you document this, especially these follow-up conversations. Make sure you make notes or send emails so that that constant accommodation can be relied on as a defense to any claim of a failure to accommodate. Thanks, and I think over to you, Rachel.
Thanks, Al. So let's dive into principles and issues when requesting medical information. So we've been sort of tiptoeing around it, but of course this is an important part of the accommodation process, and one which is often challenging to navigate. What are we collecting? When are we asking for it? What can we ask for? What do we really need? And as with everything, I think it's always helpful to think about why we are taking the steps that we're taking as we're doing it. So not to sort of just be, going through our normal processes without, fully thinking about why we're doing it. But, in terms of collecting medical information, we're taking the time to collect this information and to understand the information in order to consider whether there really is a duty to accommodate, as Katherine had talked about, and if so, to understand what accommodations are required, or as Alix is mentioning, to understand whether there need to be adjustments to the accommodations that have already been put in place. So, before really thinking about the fact that we're only collecting information that is necessary to meet our obligations under human rights legislation, there are, of course, certain things that we don't need to know. And those are up on the slide. A really commonly asked question is, can we ask for the diagnosis? Or something that we often see in forms is a request for a diagnosis. And, this is not something that we are entitled to know as employers. And that's a generally accepted principle of law. For example, I've got a quote here from one case which says, an individual with a disability, and particularly someone with a mental disability, may not know the exact nature and extent of the disability by the time they're experiencing the symptom. And in those circumstances, we really can't impose a duty to disclose a conclusive medical diagnosis. So, aside from the fact that it may not even be known at the time that we're asking for the medical information, or it may still be being investigated, it's really not something we actually need to know, because ultimately we're not doctors, or at least most employers are not doctors. So receiving a diagnosis doesn't help us understand what changes might need to be made in the workplace, or what accommodations might need to be provided to the employee. Similarly, a treatment plan, again, not something that we need to know. You might ask a question as to whether the treatment plan is being followed, but that would really be the extent of it. And same with test results. Again, we don't need to know these. We don't need to be reading charts or test results or anything like that. It's obviously very personal health information, particularly in the mental health context as well, and really isn't anything that's going to help us as employers to do what we need to do to meet our legal obligations. So let's turn now to the information that may be requested. Of course, this is probably what you're most focused on. So we can ask for the nature of the illness, and there's an important distinction between a diagnosis and the nature of the illness. So, the nature of the illness could be a mental health illness, as opposed to a physical illness or something of that nature. So you can certainly ask for that, and then you would understand that that's what you are needing to address in the workplace. We can also ask about functional limitations, including the degree or severity of those limitations. So here we're really asking, what are the employee's restrictions and limitations? What can they not do that they were previously able to do? Or, really what are the things that we need to be mindful of that is impacting the employee in the workplace? The next on the list is prognosis for recovery and expected duration of limitations. Again, a really important question. If we think about how many people live with mental health illness over the course of their lives, that doesn't mean that an individual requires accommodation over the course of their employment with you. They may just require accommodations at certain points in time, and may otherwise be able to perform the full duties of their position at other times. So, really accommodations are not, as Alix said, necessarily permanent or continuous. So prompting for a prognosis for recovery or expected duration of restrictions and limitations will help us better understand whether those restrictions and limitations are short-term or long-term, and will better allow you to assess what your accommodation plan is going to be. We also want to think about and ask questions about how treatment may affect workplace efficiency or safety. On efficiency, a physician may say that this may result in an employee taking more time in order to complete tasks, or requiring more time in order to complete tasks. From a safety perspective, we're often thinking here, and I think Alix was referring to it, we're often thinking here about the impact of prescription medications on an employee's ability to do their work efficiently or safely. So, we certainly should be asking about any impacts on efficiency or safety in the workplace. Possible workplace triggers. This is an interesting one, something that I think is helpful. It would allow you to make some adjustments in your workplace to avoid triggers for an employee. You can also ask information about an employee's ability to perform their job. Of course, at some points, or at various points in time, a mental health illness may prevent an employee from working at all. And other times, an illness may impact an employee's ability to work the full hours or the full duties of their position. So we want to know, is this an all-out, the employee's not able to work, or is it the employee can work but needs some adjustments in the workplace? And then we can ask about some possible accommodations and capacity for alternate work. Sometimes this can be tricky because, of course, a physician doesn't necessarily know what is possible in your workplace, what the nature of the job really is. Sometimes we provide a copy of an employee's job description when we're asking for this information. But of course, a physician isn't going to necessarily know the ins and outs of your workplace. So you might want to think about broadening that question a little bit to ask, whether there's any other information that would assist you in developing an accommodation plan for the employee and in accommodating the employee. That can sometimes be a little bit less charged and help you avoid having physicians weigh into how you manage your workplace. And we always recommend having a template medical questionnaire or functional abilities form that's available to you in your workplace. It's a really great starting point, but important to remember that it is a starting point, and these forms would probably need to be individualized and tailored to the circumstances of each employee. But again, still something that's helpful for you to start working from, which sort of provides you a general framework for what you might be asking about. Of course, I've made it seem all very simple. And as we turn to the next slide, we can see some common issues that that I have no doubt you're seeing with medical documentation. So often we don't receive medical that satisfies us, whether it's because it is vague or it doesn't actually respond to our request. Even if we, put very clear questions, sometimes we're not actually getting the answers to those questions. Sometimes we're not getting enough information or enough detail. And really, these issues with medical documentation can really slow down the accommodation process. But it is very important that we address the issues with the medical documentation, and that we don't just sort of sit back and take what we've received, even if we're not happy with it. And by happy with it, I mean it doesn't provide us the information that we actually need to assess our obligations and what we're going to do in the workplace. So how do we address these issues? We send specific requests for information in writing. That could be writing directly to the physician to follow up on questions that you asked that you didn't get an answer to, or if something was unclear in the responses that you received, to ask pointed questions about what is unclear to you, and to ask for follow-up information. Ultimately, our goal here is to ensure that we have enough information to go through the accommodation process. So, I've just said that's our goal. We want to go through the process. We want to know that we have enough information, but, why and what are the consequences if we don't? Ultimately, if we don't get the information and we don't have sufficient information, we may not be able to meet our duty to accommodate. And as Katherine spoke about earlier, we have both the procedural duty and a substantive duty. And so part of our procedural duty is really to inquire, and that would involve taking proactive steps to ask for information at the outset, but also to review the information and take steps based on that information, including by asking follow-up questions on the medical documentation. So this case up here on the slide was a case in Ontario where the employer argued that a medical note submitted by the employee failed to specifically identify that the employee was being treated for depression and a hypothyroid condition. The employer was already aware from other incidents that the employee was depressed and having suicidal ideas. But the adjudicator said that the employer really didn't take steps to ask for more information, and the employer essentially said that they didn't have enough information, that they didn't receive specific enough information. And the tribunal said, you have a duty to inquire. You ought to have, asked for the employee to provide medical documentation. You can't just sit passively and fail to inquire, and then on that basis refuse to provide an accommodation because of a lack of relevant information. So again, always remember that there's a reason why you're doing this, and that you need to make sure that you have all of the details and little pieces of information that you need in order to satisfy your duty to accommodate. On the next slide, some more issues that come up with medical documentation. This goes more towards the heart of, why an accommodation is being requested. Sometimes there's a very questionable basis for asking for an accommodation. And we can think critically about medical documentation we receive. We have to think critically about it, but don't overly don't unnecessarily attack medical documentation. And up on the slide, we've got some different things that you can do to follow up on medical documentation. So that would be follow-up questions, communicating directly with the physician, and sometimes in certain circumstances, an independent medical examination. Those are probably pretty limited, and there really needs to be an objective basis for requesting an independent medical examination, but that is an option that's available. I'll pass it to Katherine.
Thanks, Rachel. I would also add a common issue with medical reports during pandemic is that people couldn't get in to see their doctors. And so there was no evidence or little evidence to support. So that was a I think that's an issue that's more or less been resolved now as people are able to see their doctors through telephone conferences and video conferences and so on. Mindful of time, we only have another half hour to go. We do have several slides coming up which talk about the consequences to employers of poor disability management. And the cases that we're going to briefly touch upon are important, I think, to insert here because of the duty that we have as HR experts to sometimes explain to the business why they can't do what they want to do, because it can cost you a lot of money. The Hamilton Wentworth District School Board and FAIR is a well-known decision of the Court of Appeal. It's coming up to 5 years old now. But this is a case where an individual, Ms. Fair, was employed by the school board, became disabled, had to take a medical leave. She had a very specific job that involved the assessment of whether there was asbestos in the workplace or not. This caused her tremendous angst. When she came back or was ready to come back to work, she was permitted to participate in a work hardening program. And her doc said she can't do any job that will require her to have to give an opinion on whether something is or is not a threat to safety. So please accommodate. The school board said they couldn't accommodate. Next slide, please. That it was, they'd looked around and they couldn't accommodate her up to the point of undue hardship. And so they terminated her employment. There was no evidence that the school board didn't have the resources to find another position or that it would have caused undue hardship to do so. And as you'll see on the next slide, the consequence to the school board of not reinstating, as per the kind of advice of her psychiatrist, was that Ms. Fair was ordered reinstated, and she was awarded $450,000, which was the equivalent of 10 years of back pay. So this case is just a useful reminder that there are consequences to a failure to accommodate. Whether you fail to accommodate on the process side or the substantive side, somebody can be ordered reinstated with all of their lost wages. Next.
I think that's me next. Again, I'll just touch briefly on this case. Here we have the case of an executive director, Shelley Wells, who was terminated when she returned to work from a sick leave that she had taken due to stress. Now, that stress arose out of a series of terrible interactions in her workplace, where she experienced bullying and harassment. And these were issues that she brought to the board of directors, who she reported to for the organization. So the board was aware of these issues. She ultimately went off on a sick leave, and when she returned to work from her leave, she was terminated. Her replacement was kept on. Her temporary replacement was kept on, and she was let go as soon as she returned. So Ms. Wells filed a human rights complaint, and it really wasn't too much in debate that she did in fact have a disability. And we can move to the next slide. The employer did argue that she had not established that she suffered from disability, from a depression and anxiety, although they had previously conceded that she did. But in any event, there was an issue around whether a disability had taken place or had been experienced. And ultimately, the employer tried to defend its decision to say that there were performance issues. And the tribunal concluded that those performance issues were in part related to the stressful work environment that she was experiencing. And so ultimately, the decision to terminate was impacted by or in some way tainted by the fact that she had a disability. And they found that her replacement, hiring her replacement, who did not have a mental health disability and who was able to perform effectively in the workplace as a result, that consideration was discriminatory in nature as well. We'll just tiptoe right along into the next sort of category of damages that you might see or see claims for, and that would be damages in tort. So while, of course, human rights risks and damages are those that are most relevant to our topic of mental health today, they are by no means the only risks and damages that could result. And so we've got up on the slide here sort of a description of the tort of intentional infliction of mental distress. And this would be something that would arise in the context of a civil claim, so a claim for wrongful dismissal, for example. And importantly, the case law on damages and torts is that you really don't have to have a malicious purpose in order to have acted in a way that is calculated to produce harm. It's really where consequences are known to be certain to follow from that kind of behavior that you may encounter a finding that there's been intentional infliction of mental distress. So for that reason, we always need to look past our intent and to consider how steps taken in the workplace might be perceived from an outside perspective, regardless of our intentions. And then finally, one that you probably have heard before, seen before, and seen claims about are claims of constructive dismissal. Whether there's been a change to the terms of employee's employment or where the work environment is toxic to such a degree that the employee can treat the relationship as having been terminated by the employer. So think about, for example, when an employee resigns very suddenly in circumstances that suggest that their decision might be impacted by a mental illness or other disability. Think about phrases that we hear such as, "I'm resigning because the work environment is too stressful." And let's, slow things down when we get claims of that nature or resignation letters of that nature. Make sure you do your due diligence, take steps to determine whether an accommodation is needed before you go ahead and accept a resignation. And even if the employee doesn't seek an accommodation, make sure they understand the impacts of their decision. They've had time to reflect on it, and you really give them an opportunity to take back their resignation notice. And with that, I'll turn it over to Katherine and Alix to talk about our case study.
Thanks, Rachel. We thought what would be helpful is just to do up a brief case study and to add facts and apply what we've discussed already. So the case study is up there, pretty simple, as these things rarely are. But this person is a sales representative. He is Black. He's been a good employee until the last year when his sales declined. He's put on a PIP. It is the case that management puts all sales reps on performance improvement plans when they miss their target. Next slide, please. When the employer sits down with the employee to put him on a PIP, the employee says, "It's because of the pandemic that my sales have declined." And the question for you, Ms. Herber, is this a good excuse? Should the employer immediately change course because we are, after all, in a pandemic, and perhaps this is a good reason for why this employee is struggling? What do you think?
Well, it raises a number of issues that I think an employer should think about. The first is always, and I say this to all my clients, is the PIP being effective right now? So, when we put together a performance improvement plan, is this the right thing we should be using? So in this particular case, we see that management puts all sales representatives on PIP. So it may be very well that this is an expected part of the process for employees to improve, and therefore you can use it. But what we would say in a pandemic is we want to always be sensitive to claims that can arise out of the pandemic, because there's going to be a lot of empathy and sympathy for employees who struggled during the pandemic, and that's what we're going to see to adjudicators and judges, etc. So when you're implementing this right now in the pandemic, we should really get to the root cause of what we think could be causing the performance to not be meeting expectations. In this particular scenario, he's always been a good employee until this past year. So what's happened, right? Is it a management issue? Is it the employee is having issues, and are we really focusing in on that? If we put in a PIP, is it really going to rectify the performance? If the employee is saying that they're having really difficult times concentrating, maybe they've had other people impacted by COVID in their family, maybe they have particular stress around the pandemic and the risk factors that they may suffer from. So really thinking about why are we using the PIP right now and whether it's effectively going to get there. So the other thing that we often see is that, people will put in a PIP and they'll say, no, this employee's had ongoing issues for some time. But when you push the business on it, none of it's been documented. You don't really have any real sense that the employee knows that they were concerned. So if you've never taken the time to manage the employee effectively before the pandemic, is this the best time to be doing it? So again, looking at what your history is and what the process that you've been using and whether it'll be effective. KP?
Thank you, Alix. Rachel, can I ask Rachel to answer the next question? And that is, the employee has been put on the PIP. Does it matter that this employee is the only sales rep who has in fact missed target and that the other employees are performing well? Does it matter how other employees are doing? Rachel, do you have any thoughts on that?
Yeah. Of course. I mean, I think as we've been talking about all along, we need to be, in every case, considering this on an individualized basis and making sure that we're doing a sort of deeper dive on all of the issues. But certainly context does matter. If everyone else is doing well in sales, then, it may not be that the pandemic is, for example, causing, issues with the employees' sales because, for example, sales are up across the board. So context matters. We have to think about whether others are selling well. And then we would have to think about, why might this sales rep not be? Is their territory unique or different or has been more impacted by COVID? So those are some of the sort of contextual considerations that we should be thinking about.
Thank you, Rachel.
Sorry, I was going to jump in to say that the one thing that we've seen a lot and that you, Rachel, and I were discussing is just saying it's the pandemic may not be enough to get you into this whole mental health accommodation, right? And we've had lots of discussions around whether or not it meets the standard of being a disability. For some people, it's certainly well, and for others, it may not be. So you don't need to necessarily make that assumption that because someone may have a generalized fear about the pandemic and they're saying, oh, well, I'm not doing well because I'm not focused because it's the pandemic, whether that really reaches the standard of a disability that requires accommodation.
Thank you, Alix. And if we can just add another layer to the fact by looking at the next slide, which as you're doing a slightly deeper dive with this employee, he indicates that it's the pandemic and that during the last summer, Black Lives Matter had really affected him in a significant way. When an employee advises you of that scenario or situation, should management change course? Should it go ahead with the performance improvement plan or should it step back? Al?
That's a really good question. And I think it raises what we were discussing earlier about this principle of intersectionality, where you can't look at one thing in isolation. You have to look at the full context of what may be impacting that employee. And certainly we've heard from our clients and employees that the Black Lives Matter movement and the issues around it was a very big impact to them. And just like we saw with the Me Too movement, it has created the ability for employees to feel more comfortable coming forward to discuss some of these sort of microaggressions and some impacts that they may be dealing with in the work environment. So it's certainly not something that anyone should dismiss. They should really try and get to the bottom of what that person's experiencing and whether or not it's appropriate in those circumstances to then just move forward with a performance improvement process. And that's what we will have to say with both these scenarios is it's a really subtle process. It's not very easy to say to our clients, you just do this and you just put in a performance improvement process and you follow it along. Courts and adjudicators will expect employers to take the full context into account. And so really understanding what that employee is experiencing and trying to get a sense of that will inform whether the performance improvement process is the best way to move forward.
Thanks, Al. And just moving on to scenario 3, I'll just carry on here. Because our employer is going to be doing his or her or its due diligence, they're going to be probing a little bit more to find out what's going on. And in this case, the employee who's been put on the PIP and who's not selling well has indicated that Black Lives Matter is affecting him. He can't sleep or concentrate. He's a mess. What, if anything, should management do next with that employee, in your view?
So I think we're now in a situation where we have actual information of actual cognitive impacts to that employee, where they've now indicated, they're not sleeping or able to concentrate, and that's impacting their ability to focus on the work. So certainly, we have a duty to inquire. That's the first principle. And that we can't ignore it as employees. We need to understand, is it to the point that this person requires accommodation and therefore go down the accommodation process? And that's certainly one angle to look at it. The other way is to really look at your performance improvement process. As the words themselves indicate, the purpose of this plan is to improve performance. Sometimes we forget that it's not just about sort of punishing employees for not working well or really trying to push the employee to understand that they're not meeting expectations. It's really about trying to improve the performance of that employee. So is the performance improvement plan that you've implemented going to do that? It should certainly take into account some of the issues that the employee is facing if they're not able to sleep or concentrate. And again, we certainly can encourage employees to seek, the resources that the employer may have available to get the assistance to help them manage some of the distress that they're feeling. And then, make sure that you're sort of monitoring the performance with that context in mind.
I think that's a nice segue into our next section, which is practical strategies for supporting employees' mental health during the pandemic. And then we'll have a few minutes at the end. But I think there are some important takeaways in this piece. If you can lead us there, please.
Yeah. So let's talk about some of the key sort of focuses for supporting employees. First and foremost is to communicate with employees. So uncertainty can be a real source of anxiety. And in times of uncertainty, as are the times that we are living in now, people need clear communication as much as possible. So clearly communicate to your staff about your COVID-19 workplace plans, your openness to hearing their questions and their concerns. Doing so will really help give your employees confidence in how you're handling the situation and will promote feelings of safety and security. And really ensure that your managers and that the business has all of the information they need to effectively answer questions as they come up and to create safe spaces for conversation. Similarly, managers and the business can establish clear expectations and reassure employees that as their employer, they're open to hearing their concerns and acting on them. So, first and foremost, let's remember to communicate with our folks. Next is really to listen to what we hear back from employees. So be ready to listen, create an atmosphere where employees know that they will be heard, and establish clear procedures for employees to ask questions and to express concerns. This was much easier when we were all in offices together or in workplaces together. So for your remote workforce, this may be something that's even more important than ever. This could mean making managers available and prepared to answer questions. It could mean a dedicated phone number or email address for inquiries related to how COVID is impacting work. It could mean a virtual town hall where employees can ask questions. So we want to really reassure employees that the business is understanding that this is not a normal situation and that it anticipates the resulting effects, whether that's decreased productivity or higher stress levels, increased absences, particularly with the prolonged nature of the crisis. And, sometimes reassuring an employee just by acknowledging that the situation is stressful and could be causing them discomfort, and letting staff know that it's okay not to be okay can go a really long way and can open the door and open the channels of communication in your workplace. Next, we have to, as always, lead by example and focus on prevention. So being proactive is one of the best things you can do as an employer. So start by establishing some new practices that can help prevent negative health outcomes for people in your workplace. And we'll talk about some strategies that we've seen employers using anecdotally as we move forward. But understand also that the phrase, my door is always open, might sound nice, but and is important to say, but some employees may be intimidated to reach out to their manager about mental health concerns because of the stigma and the concerns on how that might impact their career. So consider establishing peer support networks, whether that's a regular water cooler chat amongst those who are sort of around the same level to sort of keep those communication lines open. And also consider encouraging employees to practice self-care activities throughout the day to help them manage their stress. And then last but not least, of course, is to accommodate, to follow the steps in the accommodation process and accommodate where necessary and where appropriate in order to support your employees. I'll turn it to Alix to talk about some more proactive measures.
Thanks, Rachel. So obviously, lots of our clients have worked with us to develop some strategies to proactively promote mental health. And some of these you may have implemented, and some will obviously may be something you can implement as you think through them. So obviously, you want to develop strategies that suit your work environment and that proactively promote mental health. So we actually have at our firm certain requirements now that we've never had before. And that's really around how we communicate with other lawyers and staff in the firm. And that's something we've seen that's been established in lots of other workplaces. And some of that is about, sending emails to your team as a way to lead, as a way to establish when is off hours. As we talked about at the beginning of the presentation, all the studies have told us that some of the major stressors that Canadian workers are facing is this lack of divide between their personal lives and their work lives. And so ensuring that you set boundaries around that work with your business requirements, but also give employees a sense of a break at a certain point. So, for example, off hours, not to send emails or phone calls after a certain period of time, so employees don't feel that they have to respond all the time, because as we've seen in the studies, there is an added pressure people are feeling to respond. Lots of our clients are using the delayed delivery that Outlook has, where you can set your email but have it delivered the next morning, or as some of us do, we do draft emails and then send them out the next morning so that employees don't feel the need to respond in these off hours. Certainly, we would also encourage, if you're going to sign off as a leader, to give permission to other employees to say, you know what, let's end for the day. It's Friday, it's 3:30. Let's call it a day for the weekend. And sort of leading by example that there are opportunities to take some time to kind of focus on your own mental health. And if obviously that has to work for your business. And then obviously encouraging employees to take breaks during the day. So some great examples we've seen is where employers, leaders or managers have indicated to their teams that they're going for a walk at lunch and they're not going to have their phone with them. And so you're basically signaling to your group that you're able to take time where you're disconnecting from your device to really get an opportunity to have a mental health break. Obviously, taking a vacation is important. It's harder right now. Lots of our clients have had lots of issues around people not taking vacation and managing that. But certainly now that we're a year into the pandemic, ensuring people take vacation and leading by example in that regard is really important. So, obviously when we think about, when you do meetings, thinking about who needs to be invited, whether you have meetings at times that make sense for your team is also really important. And what other things we've seen is, sometimes in this virtual environment, people don't take the time to show appreciation for the hard work or dedication that a member of your team or a group of your employees has done. So, doing those little things to really show appreciation to your team can go a long way to engaging with the employee. And then on the final slide, before we end today and answer some of the questions that have come in, some of what we've seen in the literature and our clients is a no camera on policy, right? Allowing employees not to feel that pressure of always having to present themselves in a certain way and have to be ready to be on camera, and having some days where, they can be in their casual, Lululemon clothes and track pants and hair in a ponytail or whatever. I'm not saying that I've done that. I do that on a regular basis these days, but to really allow yourself to have those casual days so you don't have to be camera ready all the time. Some of our clients have said no Zoom meetings on Fridays afternoons. Some say no meetings at all on Fridays, and some employers have given employees paid time off. There's also lots of things we've seen in this virtual world around how do you create team connection, events where you do a cooking class together, or you do, we did a chocolate tasting with some of our clients. So all of those things can add to the team morale. And so obviously that promotes mental health. And I think we'll end with Katherine asking us some questions.
Yeah, thanks very much, Alix. And I've just received permission to go until 3:35. So that's 10 minutes from now. Obviously, we know that some of you will have a hard stop at 3:30 Eastern, but for those who can stick with us for 10 minutes, that would be great, because we've had some good questions come in. This is actually two people sent pretty much the same question, and it's in respect of dealing with uncooperative doctors, those doctors who will not respond on a timely basis, or who respond with non-answers or don't answer the questions you've asked. What is the best strategy for dealing with these sorts of doctors? Rachel, do you want to lead us off on that?
Sure. So, that is a real challenge for sure. Sometimes we have to think about what might be motivating that. Sometimes, it's hard for an employee to get in to see a physician. So we need to be mindful about employees' ability to get appointments. Sometimes that can be an issue. Other times, it may be more helpful if you could even to suggest to the physician a phone call, or to really target your questions and make sure you're being brief with your questions. And then ultimately to emphasize to the physician in your communications that it's really important that they respond to you so that you can accommodate the employee in the workplace. Certainly these are challenging issues. There's no sort of one size fits all solution, but think about how you can simplify your request. Think about whether you need to offer to pay for the cost of the medical note. Sometimes that can be a barrier, or sometimes a physician might be more willing to provide answers if they know their bill is going to be paid. So think about all of the sort of different factors there and how you might try to facilitate that, and communicate with the employee. Like, try to understand whether they're having a hard time getting in touch with their physician as well. It may have absolutely nothing to do with the legitimacy of the request for an accommodation. It may just be sort of a practical issue of getting in front of the physician.
Thanks, Rachel. Alix, a question for you. This client has an employee who's required to come to the workplace, who has said that she's afraid to come to work, to go on the bus. She's afraid that she's going to catch COVID and that she will pass it on to her vulnerable son. She will not come into work. What is the employer to do?
These are very challenging questions right now. The Ministry of Labour has repeatedly said, a generalized fear to travel on, public transport is not something that they agree with. So they will be expecting employees to travel on public transport. That being said, if the person does have an immune compromised family member, you may be into family status accommodation, right? And that may be something that you have to deal with. So, Sometimes we've seen our clients willing to pay for the transportation to ensure the employee doesn't have to use public transportation. Some will do rental cars. Some will, provide for Ubers and reimburse Ubers so the person's not on public transportation. But my view is generally that if people are adhering to the public health measures and that they're wearing appropriate protective gear, they should be able to come into the workplace, and that you can't just rely on a generalized fear to support your inability to come in. I'd be interested, KP, on your thoughts on that too.
Yeah, I mean, I agree with what you've said, Alix. I think a generalized anxiety is not, does not equal a disability. But I also think that empathy and kindness in these pandemic times goes a long way. So again, I think it's exploring. It's digging a little deeper. It's exploring options, other options, as you've indicated. But that's a tough question. Here's another interesting question, and there are a couple along these lines where employees are indicating that they have an issue and that they have the solution, and that the employer should simply just abide by the solution. So we have one individual who's suffering from anxiety and stress in the workplace, and she is prepared to come back as long as she has a new manager and a new role. Rachel, what do you think of that, or how's the employer to handle that kind of direction from the employee and her physician?
I love that one. I love the request for the new manager, of course. Well, I mean, first and foremost, we go back to our basics. Do we have medical documentation for this? And if we do, what is the medical documentation saying? Is it just the employee who is saying, this is what I need? This is going to be what will make me successful at work? Look, you have to consider whether you're prepared to do something like that without medical documentation or sufficient medical documentation to support that. So look back at your medical, see what the restrictions and limitations are, see whether that there's a medical basis for requesting that type of accommodation. And to the extent that we can do things that an employee wants or likes and is going to cooperate with, that's great. But we are not beholden to what the employee decides is the accommodation they want. So, it's about reasonable accommodation. It's not about their preferred accommodation. So it is ultimately an employer's decision to, working collaboratively with the employee, but ultimately the employer's decision as to whether or not that is going to be the accommodation that is provided. Again, one of my favorite examples.
That was a good question. Whoever sent it in, thank you. Alix, I'm reserving the last question for you, and then we'll sign off. We have an individual who has indicated to his employer that he suffers from fatigue and that he needs to take a day off each week so that he can deal with the fatigue. He won't require payment. So what he's asked for is a day off so he can deal with fatigue, and we will not expect to be paid. And the question from the employer is, do we have to do this? Al?
No, I would say not without, sufficient medical support that is an accommodation that's reasonable in the circumstances. We'd have to understand, why is he only fatigued on the one day in a week, right? Are there other forms of accommodation if he can establish that there's a medical basis that requires him to work less hours than his required job entails? So that's really what he's saying. He's saying, if I'm working a 40-hour week, I only want to work a 32-hour week. And you're not required to reduce someone's work week unless, that's a form of accommodation that makes sense based on the medical. And we'd have to understand, why is he feeling fatigued? What's the basis for it? Is it medication that he's on that's causing fatigue? In which case, why would it only occur once a week? Is it the amount of work or the volume of work that's impacting him? And why isn't the weekend recovery not sufficient to sort of re-energize the employee for the following week? So no, I would say that does not seem like a normal accommodation we would do. unless there's some medical basis to support it. And I would just, I just end on, I saw a couple of questions come in around the medical documentation. So I would just add that, if you're going to deal with the physician directly, you need a medical consent to doing that. And what we generally recommend is when you're sending out the letter to the employee that sets out the questions that you need answered in order to determine what accommodation, you can also attach a medical consent which the employee has to agree to, that gives you permission to deal directly with their physician. But one thing I often put in my medical notes is a question around whether that doctor is the treating physician and has a regular relationship with that employee, as opposed to, a drop-in clinic, for example, which we sometimes see as well. So, absolutely that's one way to go, but only with the employee's consent.
Great. Well, it is 3:35. Thank you, everybody, for your attendance at our session today. Please fill out the survey, and we look forward to seeing you at Fasken events in the future. Have a great afternoon. Thanks, everybody.